Also, explanatory statements are issued. Now we have for the main content of the draft law already published. I think that would go some way to addressing the concerns expressed by the public over the past few weeks. So today I would just highlight a few key points of my views. First of all, since the 22nd of May, the National People's Congress made a decision on establishing and improving the legal system and enforcement mechanisms for the SAR to safeguard national security. It's been a month since, and then we've heard certain concerns expressed. First of all, whether this legislative exercise is in line with one country, two systems and a basic law. Now that you have read the published content of the draft law, you can see that on national security affairs, the Central People's Government has the ultimate responsibility. And then in ensuring sovereignty, unity, and territorial integrity, that's the common wish of all people of China and Hong Kong. So it is not against the principle of one country, two systems and the basic law. In fact, this law would improve upon the one country, two systems institution so that we could better ensure one country, two systems. Put simply, let's say there are acts and activities that undermine national security and one country is undermined, then the two systems would lose a solid foundation. And if people still think, under the circumstance, that the legislative exercise is undermining the one country, two systems, then I believe these people never really put one country first or bear that in mind. Now, the second concern is whether this legislative exercise at the state level is constitutional and lawful. Now, we have the highest power organ in the country, that is the National People's Congress, that made the decision to delegate the powers to the Standing Committee of the NPC to enact the legislation. That's Constitution 31, and that's Article 31 and 62 of the People's Republic of China's Constitution. And also, after the law is passed, it will be included in Annex 3 of the Basic Law for promulgation and implementation in Hong Kong. So the legal basis is crystal clear. There is no there's nothing unclear about it. And the third concern is after the law is enacted, would Hong Kong people continue to enjoy their rights and freedoms? Will their rights and freedoms be protected? Now, I think in the published content of the law, you will see that only 4 types of crimes are to be targeted by the law. Later on, when we see the provisions of the law, we'll see what the definition is for the 4 types of criminal acts undermining national security. And all in the content published, it stated clearly that the law must respect and protect human rights. And for human rights and freedoms to be protected, they're in line with the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. And it's stated clearly that these rights include press freedom, freedom of assembly, protest, and so on, and assembly. And then the 4th concern is from the legal sector. That is, this is national law. So would the concepts of the common law be included? Last week, I said, well, not as an expert, but I said that for different types of law, the common law, other laws, they may share certain common features, and these features include the rule of law principles and concepts. Now, for the published content, you can see clearly that the rule of law principles are included. For example, it states clearly that if an act is criminal, then in nature, then it's punishable, or it's a principle of no penalty without a law. That means in future we know exactly what act is unlawful and what is not. And the second rule of law principle is presumption of innocence. And the third rule of law principles is to protect the rights of the accused or the suspects. That is the right, say, to defense. And the fourth principle is if someone has been acquitted, then the person could not be punished again. That is the prohibition on double jeopardy. Of course, in the past month, there are other views expressed. And so far, these have not been touched upon in the published content, that is the retrospectivity. So would this law be retrospective? We do not know yet, but if we follow the rule of law principles, and this is a criminal law, well, there is the same concept on the mainland. That is, there is no retrospective effect usually. Only acts committed after the law comes into effect would be covered. Now, another concern is whether this law will be fully applied in Hong Kong here. Now, it's stated clearly in the draft law that the Hong Kong SAR government will take responsibility for enforcing the law, but there will be a handful of cases, of special cases. Now, the SAR government, of course, has major responsibility in implementing the law, and will also be exercising the jurisdiction given will be exercising jurisdiction over the law. Now, but how do we fulfill our responsibility as the main party? So, at the government level, we have to enhance our enforcement capacity and the institution. So, therefore, the Chief Executive will chair a commission for safeguarding national security. As for the membership, it will be stated in the principal law. There will be two main departments involved. One is the police force, the other is the Department of Justice. So there will be dedicated sections in handling national security matters. Now, we've also heard often whether the national security law will undermine the judicial independence in Hong Kong. Now, I must stress that judicial independence is key to rule of law in Hong Kong. As the Chief Executive, since I assumed my office, I have always attached great importance to judicial independence. I have full respect for the judiciary, and I fully support their work. I've said this before. So this will not undermine judicial independence. And after the decision was announced, the Hong Kong and Macau Affairs Office issued a statement to say that the law would not undermine Hong Kong's judicial independence and high degree of autonomy. But then here, I would like to say this. There are 160 articles in the Basic Law. There's much mention of the judiciary, 17 articles from Article 80 to Article 96. Now, I don't see for the contents of the draft law already published, I don't see which provision actually is in conflict with any article of the Basic Law. Now, the most important is that the courts of the Hong Kong Special Administrative Region exercise the judicial power. They should be free from interference. And then it's said that there should be restriction on nationalities in handling certain cases. Well, this is the case with some other cases, not just not national security law. Now, in the published content of the draft law, actually, there's no mention of no mention of the nationality issue of judges who may preside over trials on national security cases. I think that's to show full respect for the and confidence and confidence in the judicial independence in Hong Kong. Now, the chief executive is to appoint a number of judges to handle national security cases. Some criticize that that's to destroying our judicial independence. Now, I haven't read the articles, the relevant provisions yet, but I would like to refute that criticism here. So, what does it mean to say that to appoint a certain number of judges? Here, it means that the chief executive will appoint a list of judges from the magistracy level to other levels of the court in advance. So I must stress, it's not the case that the chief executive will appoint a certain judge to preside over a particular case. No, it's not like that. So I have to make that clear. In other words, in future there will be a list of judges at different levels of the courts, and there will be a number of judges at each level of the courts. And then when that's going to be a national security case, now on which judge would be appointed to hear the case, that will still be the responsibility of the judiciary. Maybe there's cases to be heard at the Court of Final Appeal or at other courts, and we will still follow the same practice. So it's not for the executive or the chief executive to appoint a certain judge to preside over a case that's to be heard in a particular level of court. No, it's not like that. And I hope you will get that clearly, because I've heard certain criticisms saying that the executive is the prosecutor, and then the prosecutor also decides which judge will hear the case, and that is totally wrong. Now, second point I would like to say is that now who is the person appointing judges? In Article 48(6), that is Article 48, paragraph 6, it says that the chief executive is the person to appoint judges of the courts at all levels. And then just now I mentioned Article 88 in relation to the judiciary. It already states that the chief executive will receive recommendations of an independent commission, that is the Judicial Officers Recommendation Commission that we have now. So for some so-called appointed judges to hear national security cases, we'll still go through the same process. So put simply, the chief executive is not just going to appoint anyone on the street to be a judge on national security cases, but rather there are already judges serving at different levels of the courts, and then the chief executive appoints some of these judges to hear national security cases. In other words, for the judges that could be appointed, or the pool of judges who could be appointed, they have already gone through the time-honored process of independent recommendation of an independent commission. So, therefore, the chief executive's appointment of judges on national security case would not change that. But of course, we must not forget that ultimately it's the chief executive who has the power to appoint judges. Well, we've been saying that, but perhaps not made clear that now. Some say that the chief executive only appoints the chief justice, appoints all judges except the chief justice, but that's wrong. Even for the chief justice, it's the chief executive who appoints a person. But of course, we have to. The chief executive will make the recommendation, and then the record has to be made with the National People's Congress. And then last week, the Legislative Council approved the resolution put forward by the administration to appoint Justice Andrew Cheung to be the next Chief Justice. I'm now, going through the process of submitting this recommendation to this appointment to the National People's Congress for record, and then Chief Justice Andrew Jack could then become the Chief Justice on the 11th of January 2021. Sorry. Now, of course, I heard there's been much opposition to this appointment, and I find that regrettable. I think it's undue politicization of judge appointment. So for such votes against the appointment or such exception votes is a show of disrespect to judicial independence. And then in Article 92 of the Basic Law, that's my third point, judges are chosen on the basis of their judicial and professional qualities. We may also recruit judges from other common law jurisdictions. For appointed judges on national security case, that arrangement will not change. The fourth point. Now, as on the appointment of judges to preside over certain cases, this is not rare. This is not uncommon in Hong Kong and in other jurisdictions. I note that the Secretary for Justice gave some examples yesterday. Now, there are commercial law courts or other arbitration courts, and they do have a predetermined list of judges. And say if there are arbitration cases, and then judges will be selected from that list. And then there are also special courts to deal with certain cases. This is also allowed under Article 81 of the Basic Law. For these special courts, again, the judges presiding over these courts are appointed by the Chief Executive. Now, if people say that is unheard of for the Chief Executive to appoint judges to preside over certain cases, well, that means they're rather ignorant. I can give you plenty of examples. Just yesterday, I appointed Justice Michael Hartman again to be the presiding judge of the tribunal on misconduct cases. Market misconduct cases, and so the Chief Executive has the power to appoint him, but of course the law provides that I must consult the Chief Justice first. And there are plenty of other cases of appointment of judges by the Chief Executive, say the Land Tribunal. Again, is for the Chief Executive to appoint a High Court judge to preside over the tribunal. And of course, the High Court judges are appointed by the Chief Executive. They are either judges from they are judges of the District Court and other deputy judges to deal with land dispute cases. And another example is the Labour Tribunal. The Chief Executive is the person to appoint one or more than one magistrates to handle labour dispute cases. Now, no one has ever said that such an arrangement is undermining judicial independence. But now, when it comes to the national security law, this is a national law. The purpose is to safeguard national safety and to punish acts and activities that go against national security. Now, I just mentioned market misconduct, in relation to securities and so on. Now, isn't this national security law even more important in that sense? So how come when it's for the Chief Executive to appoint judges to handle national security case, it should lead to so much controversy? Now, finally, we have full confidence in the judicial system in Hong Kong. We have a high degree of confidence in all the judges in Hong Kong, because for all of them, when they are to assume office, they have to swear allegiance to the SAR, and then they also pledge that they will be unbiased and they will serve the SAR without fear. So I think for the chief executive to appoint judges to handle national security case is not going to undermine our judicial independence at all. Now I'd like to say something about the employment support scheme.
I don't know what's wrong with the mask today. It doesn't work very well. Perhaps it's a bit loosened after multiple washes. Today, we have the third batch of successful applicants under the ESS. Within this week, we have 30,046 employers in the third batch receiving subsidy, involving 345,000, involving an amount of $7.76 billion. For SME employers employing less than 50 employees, they account for 97%. In the last batch, they accounted for 98%. So it's similar. After the 3 disbursement of subsidies, altogether, the number of employees approved stands at 89,474. That's 53% of total number of applications. We received 160,000 applications. The number of employees under the ESS protection stands at 836,285, and the total amount involved is $19.1 billion. As for self-employed persons, for the 3 batches altogether, the total subsidy amount stands at $560+ million. That's the sum for some 74,300 self-employed persons. So I worked out the sums last night. Judging from the present circumstances, the total amount approved under the ESS might be very close to $8.1 billion. But like I said before, the government is committed